Thank you, Chuck. I've been given the unenviable task this morning of condensing the 40-minute talk last night into 6. So we're gonna put on the jets here. First of all, thank you to Chuck and Jane, my conference co-planners, for working on the conference today. Also to Ben and Jana, who I don't think have gotten much sleep, the student organizers here for yesterday and for today and all the work that they've done. So my job this morning is to give a historical arc of the contemporary rights of nature work. Starting in the 1970s with a guy named Professor Christopher Stone. He's a professor at USC. Wrote an article called Should Trees Have Standing? About rights of nature. And essentially, for folks that weren't here yesterday, may not have attended the talk last night, we're talking about the legally enforceable rights of ecosystems. So we talk about rights of nature, that's the shorthand. Legally enforceable rights of ecosystems, essentially elevating protection of ecosystems to the same level that we protect human rights, civil rights within the system of law. So elevating them to the highest protection system that we have under Western European legal system. So while some folks trace the rights of nature and legal standing for nature and ecosystems back to Christopher Stone in the 1970s, we have to all understand that this was not an invention of a law professor, that nature as something other than property goes back to indigenous belief systems for 10,000 years. That indigenous communities have always held that nature is something other than property, that nature can't be owned, that it has a different kind of status. And so kind of the awakening in the 1970s, if we want to call it that, was really just a recognition by some Western legal systems that this indigenous system of understanding nature was needed within the Western system to add another level of protection for ecosystems in the natural environment. And also recognizing the work of Thomas Berry. I don't know whether that name means something to folks, but Thomas Berry, a Catholic priest, he used to call this shift from a Western thinking of nature as an object rather than a subject of rights. This shifting he called the great work that needed to happen, this transition from one system to the other. And as he put it, shifting to a communion of subjects from a collection of objects. That was the great work that Thomas Berry talked about. So there was a lot that happened between the 70s and 2006 in terms of people thinking about this stuff and bringing some early lawsuits dealing with animals as plaintiffs, for example, under the Endangered Species Act. In 2006, our work began in a little place called Tamaqua Borough, just northeast of Philadelphia, in which there was a project to dump PCB laden dredge from the Hudson and Delaware rivers into open mine pits in Tamaqua Borough, this really small borough. We assisted them to write the first law that recognized rights of rivers and ecosystems within Tamaqua Borough. Basically a response to this project, corporate project, to dump this PCB laden dredge into the community in Tamaqua Borough. And then in 2008 in Ecuador, the Ecuadorian Constitutional Assembly was meeting, elected Constitutional Assembly within the country, to write a new national constitution. They had heard about what had happened in Tamaqua. Tamaqua made national news and circulated within certain circles. The Ecuadorian Constitutional Assembly contacted us to come down to Ecuador to assist with the writing of the new national constitution in Ecuador. They wanted to insert rights of nature, this rights-based system of ecosystem protection, into the national constitution, becoming the first nation to switch from what we refer to as a property-based system of environmental protection, in which those who own the most property can destroy the most ecosystems under that system, which is the one that we have, to a rights-based system of environmental protection. And in 2008, by a vote of 67%, so overwhelmingly, the public ratified that new Ecuadorian constitution, and with the rights of nature provisions in that constitution, and have since brought cases underneath that constitution. First case dealt with a river as a plaintiff. Sometimes this bends our brains a little bit, but the Vilcabamba River versus the province of Loja was the first case in which a judge ruled in favor of the river as having certain rights against dumping of road debris, changing the course of the river flow for the Vilcabamba. In 2010, and Doug Shields, former president of Pittsburgh City Council, is going to talk more about this today, but in 2010, Pittsburgh passed an ordinance banning oil and gas extraction, fracking within the city of Pittsburgh, and recognizing the rights of the three rivers and ecosystems within the city by a unanimous vote of the Pittsburgh City Council in 2010 adopting that law. There's been a lot of work by tribes, so indigenous communities who are inserting rights of nature provisions into their tribal constitutions and passing laws within that tribal framework. They include the Ho-Chunk Nation in Wisconsin, the Ponca Nation in Oklahoma, the Ojibwe in Minnesota, and the Yurok tribe in California. Yurok tribe being the most recent, adopting tribal law that recognizes the rights of the Klamath River within Northern California. There's also been a national legislation other than Ecuador, trying to put this in different categories. So indigenous communities, legislation at the national level. People may know about the Uganda law that passed just last year, the National Environmental Act of 2019. It declares and establishes, quote, a right to exist, persist, maintain, and regenerate nature's vital cycles, structure, functions, and its processes and evolution. So they're the latest national legislation to be passed that recognizes the rights of nature. The Bolivian law that was passed dealing with rights of Mother Earth, also at the national legislative level. And then we have this interesting thing that started to happen that Gabrielle is going to talk about. And the fact is that courts began to move without national legislation at all. So in some countries, courts began to use the Ecuadorian constitutional provisions as customary international law. So recognizing it as a new emerging international norm for environmental law, not needing national legislation, but creating jurisprudence purely on their own. That's happened in Colombia with the Colombian Constitutional Court in 2016 and 2018, where they recognized the Rio Atrato River as having rights to protection, conservation, maintenance, and restoration. They've also ruled to protect the Amazon region as being a person of sorts, having ecosystem rights. State courts in India have also recognized rights of nature, specifically the Ganges and Yamuna rivers as legal living entities having the status of legal persons. And also the High Court of Bangladesh, which recently ruled that all rivers in the country were legal persons. And perhaps the most recent development, the Menominee tribe in Wisconsin, tribal nation adopted a resolution recognizing the Menominee River as having legal rights as well. So as I said last night jokingly, I got an email from a law professor colleague who said, what the hell's happening with all this stuff? And that's the Cliff Notes version of what's happening across the world with rights of nature. Stuff is moving. So, sometimes we sit and we say, should we, could we? We play the devil's advocate and go through these twists and ties in our brains, but there is no could we or should we, it's happening. Yeah. It's happening now. It's happening within the courts, it's happening within national legislatures, and if there's a unified field theory, if there is one, it's that people have come to recognize that the existing system is failing us, that we're committing mass suicide in some ways, that this Western system of law that treats us somehow as separate is not working anymore. And indeed, some would say it never has, and that we need to return or give birth to this new system of law that sees us as being a part of something rather than being separate from that. So on the philosophy side, that's where I think the push is coming from. So finally, just to finish up, there's a bunch of other work happening that hasn't resulted in legislation yet. The test is not necessarily has a law been passed, but is there a new consciousness building? And Florida, I think, is a really good example of that with these county efforts moving forward, people recognizing something new is needed. The big work, big ticket items that we're working on right now in Nepal, they're talking about our rights of the Himalaya. So that's, working with the national legislators as well as community groups who are working on the Himalaya, rights of the Himalaya. In Australia, it's the rights of the Great Barrier Reef. So a Bill of Rights for the Great Barrier Reef. There's a lot of other stuff happening in places like Ireland, England, Mexico, there's some localities passing rights of nature law. So again, it's happening, it's moving, and as I said last night in the US, because of what's happening in Florida, this is the new front lines in some ways for the rights of nature movement.
Yeah.
Thank you.
Yeah. Well, thank